My name is Julie Negevin. I'm an attorney here at Gracing Mazio Law in Philadelphia. My practice specializes in real estate litigation, and construction litigation. I'm doing this video series on arbitration in construction disputes, and today we're going to talk about what are the terms of an arbitration provision that you want to see in your contract. So again, the arbitration provision is only going to be a paragraph or two in a longer contract. In the AIA contract, or in the general contract, or in the subcontracts. So the first thing you're going to want to make sure the arbitration provision specifies is the scope of the disputes that are subject to arbitration. Usually it's the broadest possible language, which is all disputes arising out of this contract, whether in law or in equity. And that all disputes arising out of is the broadest language that can be used in an arbitration provision. So you would want to make sure that every place you have an arbitration provision, that's the scope of the dispute. Next, you would want to articulate which arbitration firm is going to handle the arbitration. Usually it's AAA, but there are multiple different firms around the country that handle arbitrations, and you would want to specify that in the arbitration provision. All of these firms have rules and regulations within them that govern how the arbitration proceeds. You would want to specify that you want the commercial rules and the construction rules if they're available. Next, you want to make sure that the arbitration provision specifies how the arbitrator gets appointed. Whether you're going to have one arbitrator or a panel of three, you need to be very specific about how those arbitrators are appointed and when they become effective. Next, you're going to want to say in the provision whether the arbitrator is going to provide a reasoned award or not. A reasoned award describes all of the facts and the law that applies and comes to a decision, and it's a long document usually. A non-reasoned award is just winner, loser. Sometimes that's better because winner, loser, there's not much to fight about. But that's the last thing you need to put into your arbitration provision, that the arbitration award is final and binding and non-appealable. If you have all of those things in your arbitration provision, you should be in good shape.